talks to wrap up the afternoon. And I start with colleagues. I start with colleagues from the business schools. I get Patel and Rob Nash, who were instrumental in bringing Mike Jensen here a couple of years ago, and I thought it would be right for them to be able to talk about what's happening in their worlds, and particularly the question of how notions of keeping one's word varies from culture to culture, from place to place in the world. So I don't have a mic, but Ajay Patel does, and I turn things over.
Thank you, Ellen. So this is some work that Rob Nash and I are going to do for the law review, and it's really going to be summarizing what role culture or national culture plays in corporate finance decisions. So again, everybody's aware of this. We've heard about the Jensen-Meckling piece. So what I've done is I've just put in red some of the words that I want you to be aware of, because we're going to come back and use them. So clearly we're talking about two parties. Could be a principal and an agent. These two parties need to have different interests, and to the extent they have different interests and they act in their own self-interest, then one party is probably not going to act in the best interests of the other party. And that's where you typically end up with the conflicts that we've talked about. So here's one way we think about it. So you've got some beliefs and preferences that individuals have, and based on those beliefs and preferences, they behave in a particular way. And then based on that behavior, you end up with outcomes. And to the extent people's preferences are different, you end up with outcomes that potentially result in conflicts. Okay? Now, what Jensen and Meckling also go on to suggest is that there are mechanisms by which you can try to reduce some of these conflicts or limit the divergences. And you can do that through incentive alignment. He's talked a lot about compensation. I'll bring that up. There are costs involved that the principal may have to incur through monitoring. There could be costs the agent incurs bonding. And then there are deadweight costs, losses in the firm value that will come about through all of this. And that's what we refer to as agency costs. Now, here are some simple ways in which, in corporate finance at least, we try to limit some of these divergences. So I'm starting at the highest level, where we could say there are formal institutions, rules of law, that try to curtail how people behave to try to protect the interests of competing parties. And then you can start coming down to the firm level and say, what are some monitoring mechanisms that companies use? And these are just two simple examples. One has to do with capital structure. So to the extent the firm has excess cash, you want to absorb the excess cash, you can use debt to absorb some of that excess cash. Or we can use corporate governance, board structures to try to monitor how managers behave. There are bonding mechanisms that we can think of where costs are imposed either through covenants on what you can do or through loan terms where the borrower then imposes certain restrictions on you. And then obviously at the individual level we can start thinking about incentive alignment through compensation contracts. Okay. Over the last decade, I would say, at least in the financial economics world, there's been growing interest in thinking about things a little differently, thinking about why people behave the way they do. Not along the lines of what we just heard Professor Jensen talk about, but in a slightly different way. So going all the way back to Coase, who made the statement that, you know, institutions matter. And then North went on to say, well, not only do they matter, institutions are the rules of the game, where those rules consist of both informal constraints and formal rules. LLSV went on to build this whole literature on the law and finance space, which really focused on the formal rules. Okay? And then I would say Coffey may have been one of the early ones who brought up the issue of, you know, do social norms matter? And started getting into what clearly Siegel would think about as the informal rules, the unspoken, unwritten rules of the game. And what we're going to focus on are these unspoken, unwritten rules of the game. So if we redrew the graph, we may want to think of at the national level, culture values social norms, which then impact people's beliefs and preferences. And to the extent those cultural norms or social norms are different, then those beliefs and preferences can vary across regions, which would then result in different behavior, which would then result in different outcomes. Okay? Now, while we're going to focus on, national levels of social norm, we can take it a notch down, which is something Rob and I and Stephen Bryan, our other co-author, have been thinking about, is within national culture, you have variations in corporate culture. And they have their own set of norms. And then within corporate culture, you could have units, the trading rooms at JP Morgan, that might be different culturally than other units within JP Morgan. And then you can come down a step further and say, even within the trading room, you've got the London whale who, for whatever reason, whether it's high levels of testosterone or overconfidence, clearly have preferences that are slightly different, which results in behavior which potentially results in conflicts. So we can wrap a lot of this in, but we're going to stick at a very high level of national culture. So why do we think this is important? Well, one, we, at least in finance, believe that this allows us to look at things in a much more multidisciplinary way, which we have not tended to do a lot of. It complements the law and finance literature. So it's not that law and finance doesn't matter, it's how can this add to what we know about law and finance. And then we're hoping that this would also provide policy prescriptions when we're looking at cross-national or cross-sectional variation in contracting and contract design. So here's a little bit about the literature that we've seen over the last 10, 15 years. Most of the early work started in international business and management, and then slowly started creeping over into finance, and I would say most of the work that's being done now on culture and finance really is coming out within the last 5 years. Now, if we think of differences in culture impacting agency conflicts in different ways, and therefore impacting contracting costs, it's not surprising what we would expect to see. So to the extent cultural distance increases between two parties, you're less likely to see a merger because integration is going to be more difficult. And so you're more likely to see a joint venture occur. And that would be the first paper. To the extent people in different cultures view or perceive the costs and risk related with debt differently, you're going to see different levels of debt being used. So capital structure will start varying. Stills and Williamson actually looked at religion and language as proxies for culture and actually linked it back to protection of investor rights. And what they essentially found was that creditor right protection is stronger in countries that are primarily or predominantly Protestant as opposed to Catholic. They also found that within Protestant countries, it didn't matter whether you were common law or civil law, there was really no difference in the protection of creditor rights. However, within civil law, the protection of creditor rights was stronger in Protestant countries than they were in Catholic countries. So there is that linkage there. Guiso et al. Looked at trust and how trust actually increases equity market development. I'll talk more about cash balances a little bit. Not surprising, as cultural distance increases, contracting terms, borrowing terms between a lending bank and a borrower will vary. The more culturally distant the two, the smaller the loan, the higher the interest rate, the more severe the loan terms. And again, not surprising. I'll talk a little bit about risk-taking in a minute. And then going back to M&A, it shouldn't be surprising that the more culturally distant the acquirer and the buyer are, the smaller the gains that come from these acquisitions. So culture may be unspoken, unwritten, but sociologists and cross-cultural psychologists have figured out a way of trying to measure it. It may not be as precise as financial economists may like, but it's been used quite a bit. To the extent it's imprecise, some of the results we're going to show you shouldn't be there. So, imprecision here should bias against us actually finding anything. The three primary developers of these dimensions are Hofstede, who used surveys of IBM employees, Schwartz, who has 6 dimensions, there are 3 bipolar dimensions, and he used teachers, and then you've got Englehart's World Values Survey. I'm going to focus on Hofstede's measures. There are 5 dimensions of which I'm going to focus on 2 of them, but Hofstede is the best cited among these sociologists and cross-cultural psychologists. So which are the two that we believe we can link back to theory? One dimension is known as individualism. And what individualism measures is whether the interests of the individual prevail over the interests of the collective. So let's think back on agency conflicts. If we have countries that score high on individualism, what we're saying is people in those countries are going to act in ways where their self-interests prevail over the interests of others. To the extent our interests don't match up, we're going to end up with larger agency conflicts, which will end up with larger contracting costs. And so we link it as high individualism scores, high agency conflicts of interest, and now the question is, how should that then manifest itself in corporate decisions? So I'm going to use a study that looks at how individualism may or may not be linked to risk-taking, managerial risk-taking, and then our work that looks at whether or not it's related to the structure of compensation, the alignment of interest between shareholders and managers. The second dimension we're going to look at is uncertainty avoidance. And this has to do with whether people in that culture are uncomfortable with uncertainty, whether they feel stress with unpredictability. And countries that score high on this have people that want more structure in their lives. And we can also think of religion as manifesting itself in certain ways in some of these cultures. So hierarchical religions like Catholicism tend to be more predominant in countries that score high in uncertainty avoidance. Now, what would we expect? High uncertainty avoidance, you'd probably expect managers in these countries to hold higher cash balances. We'd expect less equity to be used in the compensation mix. We'd expect more cash to be used because it's more certain. Okay? So here's a study that actually looked at whether or not there was a relationship between measures of culture, individualism and or uncertainty, in this case it was uncertainty, and whether or not companies held cash balances consistent with that. What they hypothesized and found essentially is that firms in countries that score high on uncertainty avoidance actually do hold more cash relative to countries that score lower on the uncertainty avoidance measure. Now, what they also found was that holding uncertainty avoidance constant, as the firm's internationalization grows, as they get exposed to other cultures, other practices, local culture starts becoming less important to them. So uncertainty avoidance starts decreasing in importance as the firm starts becoming more global in its operations. It's still there, but it's less important. This is a working paper. Well, the first one was a working paper too. So this is a more recent working paper where they look at, does culture explain risk-taking? And they use something known as a hierarchical linear modeling approach, where they look to see, do firms or managers at firms with higher scores on individualism in that country end up taking more risk? And what they do find is risk, as the two measures that they use, one being the standard error of return on assets, they actually do find higher risk-taking in those firms. They also find a negative relationship between uncertainty avoidance and risk-taking. They did look at a third measure, which is harmony from Schwartz. They did find results consistent. I'll stay out of that because I don't want to get into explaining Schwartz's measures. But there is evidence consistent with cultural dimensions explaining levels of cash and cash holdings. This was true after controlling for formal institutions. So they looked at the rule of law. They looked at the anti-self-dealing index, which measures the protection of minority shareholders. And after controlling for formal institutions, after controlling for economic development in these countries, these cultural dimensions actually do hold up. And since they're looking at data between 1997 and 2006, they actually conclude that even in a highly globalized world, culture seems to impact decisions that people are making. Okay, now what I'm going to do is go to our work. So Rob and Stephen Bryan and I have been working on compensation-related issues for maybe a decade now. And we've recently moved into culture and compensation. So let me show you a little picture from an earlier paper of ours. So this is some data we've hand collected, or my students of ours have hand collected, or have been hand collecting for years, and they continue to do that because we've got to keep updating it. But what this does is shows you what is the proportion of equity, equity being both restricted stock and options, relative to total compensation in the compensation mix for the CEOs from US firms versus non-US firms. And there's clearly a couple of things that pop out. One, US firms use a lot more equity in the compensation mix than non-US firms. Two, there is time series variation. And we've all known of this. Equity comp went up till about 2000, market crashes, equity comp started coming down, and you can clearly see that there. It went from about 35% to 50%, and it came down a bit. And if you take 2006 out, it really hasn't come down a whole lot. What Rob and I know through some other work is it switched over from options to restricted stock, but the proportion of equity is still pretty high. If you look at the non-US firms, it started from virtually nothing, 2, 3, 4%, went all the way up to about 20 and has drifted back down. The third thing that we found surprising about this is that wedge between US and non-US doesn't seem to have gone away in those 14 years. So yes, there's something at the country level going on. The question was what? We had done some work on law and finance, and so we said, okay, let's split the data by legal origin. Because we knew legal origin was related to equity market development. And to the extent equity markets are more developed, you're more likely to use equity in the compensation mix. And so we said, split out common law from civil law, and let's split out US common law from non-US common law. And what we find is the US uses a lot more than non-US common law, and non-US common law uses a lot more than civil law. And again, surprisingly to us, that wedge doesn't seem to go away. So what we then assumed was, okay, there's got to be something at the country level. It's clearly not being captured by legal origin. Could it be the unwritten, unspoken rules of the game? Is it culture that potentially could explain some of what's going on? So to study that, we had to get the data, and that's where we got the data from. So it's just ADRs. So these are obviously larger firms relative to the companies back in the local country. They're level 2 and level 3, so they have to report data on compensation. And so we had students go through the Form 20F to actually hand collect all this data. So let me be upfront and say, to the extent these firms don't look like or represent the firms back at home, then we shouldn't find a whole lot in our data, because these are going to be more like the US firms than they're going to be like their domestic counterparts. We do look at structure, because we believe structure allows us to link it back to agency theory. So we're not looking at levels of compensation, which a lot of people do look at. So here's the first graph we looked at. So we said, okay, we believe individualism should be related to the amount of conflict that exists, and to the extent you use compensation to reduce or align conflicts, countries with high individualism scores should use more equity in the compensation mix. So we took the 43 countries we had, including the US, ranked them based on their individualism scores, dropped them into 4 quartiles, and then looked to see what is the average use of equity by the firms in each of these quartiles. And lo and behold, low individualism scores doesn't seem to be a lot of difference, and then as the individualism scores go up, the ramp up in the use of equity is quite dramatic. Now this includes the US, and we know the US uses a lot, so we said, okay, let's pull the US out. Do we still get the same graph? And the answer is yes. Quartile 4 may drop from 42% to about 35%, but that ramp up is still up there. So it's there in the univariate at least. We were interested in uncertainty avoidance. So do countries with high levels of uncertainty avoidance use more cash, very little equity? Or the counter would be, do countries low on uncertainty avoidance use more equity? Same thing, sort them in quartiles, and we get exactly what we would expect. Pull the US out, quartile 1's numbers drop, but that negative slope appears to be there. Now these are univariate, and we know we can't rely on this, and so we have to control for things. So we ran something known as the Tobit model. It just accounts for the fact that we've got data that's truncated at 0 on one end. The standard errors are robust. We use proxies, and I'm going to show you that for firm agency problems. We use fixed effects for the industry and year. And what we're really interested in is, do these dimensions of culture and measures of legal environment actually show up the way we would expect it to show up? We use the protection of minority shareholders. We use the anti-self-dealing index to measure that. We use the enforcement of laws, and we use the rule of law index for that. And what you would expect is stronger enforcement of laws, better protection of minority shareholders. You're more likely to see equity in the economy, and you're more likely to see equity being used for compensation alignment. Fairly standard in the comp literature. These are some proxies that are used for firm agency problems. Growth options is a proxy for the investment opportunity set or asymmetric information. You'd expect larger alignment needs when growth options are high. Larger firms have been documented to use more equity in the comp mix. Free cash flow, depending upon whether you're using Jensen's argument of the agency costs of equity or results that have been documented, it could either be positive or negative. Leverage would be a proxy for the agency cost of debt. So as conflicts between bondholders and stockholders increase because of the increased use of debt, you'd see less equity being used in the comp structure, and that's what you'd expect to see there. So again, we'd expect individualism to be positively related, uncertainty avoidance to be negatively related. So here's the regression results. What we're really interested in, one, if we just looked at the legal variables and these firm controls, are the two legal variables positively related? And they're highly significant. We do find that size is positively related, growth options are positively related, leverage is negatively related. Now obviously the two variables of interest to us are individualism and uncertainty avoidance. And what we find is when we add them to the legal variables and the firm proxies and the fixed effects, they are positive and negative, both individually and when combined with the other two legal variables. So at least here we've got some evidence that both culture and law at the firm level do matter. One of the recommendations made to us, and I presented this at the AFA meeting in January, was you really don't have 27,000 observations. You've really got 43 observations because you've only got 43 countries. So one recommendation was rerun this at the country level. And so what we did was we ran a regression using the Tobit model where we had the firm level controls, we had dummy variables to capture the country fixed effects. And then we took the country fixed effects out to say what proportion of all this variation in compensation is being driven purely by the country level factor. Okay? And then we took that out and regressed our measures of culture and law on those country fixed effects to see how much of this country factor can we explain. Because in the earlier part, we don't know whether it's 5% or 50%. So this is the regression there. So now what we're trying to do is explain just the proportion of the country factor that these variables pick up. Individualism on its own explains about 25%, which means there's about 75% left over. We don't have a perfect match here, but at least it's 25%. You add uncertainty avoidance and you get about 13%. You add anti-self-dealing, you get about 8. You add rule of law, you get about 7. So off the bat, it tells you culture seems to be more important than law, at least here. And then when you start adding them all together, what you're going to see is when I have all 4 variables in together, there's only marginal improvement over where we started, but actually it's less than what the 2 culture variables themselves explain. And so at least early on what we're seeing is while law may matter on its own, once you've added culture to it, the legal framework really doesn't seem to provide a whole lot, which I think was surprising to us. We weren't actually expecting that. Now, as good reviewers would, they threw a lot of stuff at us and told us why we were wrong and where all we were wrong. So one of the things we were told was, well, you've got an omitted variable. Your model's missing something, and that omitted variable, they didn't tell me what it was, but that omitted variable is actually correlated with compensation and culture, and that's why you're getting what you're doing. So we had to devise a way of trying to figure out how do we deal with that. And so we then randomly started assigning these Hofstede culture values to each country and rerunning the regressions. And we did that 2,000 times to see, using these simulated regressions, what does the average slope coefficient look like? And if these randomizations are essentially nonsense, then we should get a slope coefficient close to 0 or 0. And that's essentially what we find. Now, when we tested using this distribution to see what our slope coefficient is, it's significant at the 1% level, that it's not going to happen just ordinarily, at least the individualism piece. We also looked to see, does globalization matter? And so one hypothesis is, well, the market for labor is more global, and so local culture shouldn't matter. So under the assumption globalization results in less cultural effects, we use traded versus non-traded goods as a proxy for the globalization of that firm and the likelihood that they would pick global CEOs or CEOs from the global labor market. Essentially what we find there is, while non-traded goods, or for non-traded goods, culture is more important, it's still important for firms with traded goods. It doesn't go away. And then finally, we used lots of different measures of or alternative proxies for culture to make sure that the results were robust. We used a dimension of Schwartz, we used religion, we used language, and instead of trust, we actually used distrust. The more I distrust you, am I going to be using less equity because I'm less willing to put equity into the mix? And sure enough, we do find that it is significantly negatively related. So overall, what do we believe this literature is beginning to provide us? I think it's telling us culture does matter. These unwritten, unspoken rules do matter. Now, we're not sure specifically how much of it explains in each of these different contracting decisions, but it's there. We are able to link culture back to agency theory and actually develop some testable hypotheses. And then using dimensions from sociology and cross-cultural psychology, we can actually test those hypotheses using either time series or cross-sectional data, and we believe the evidence is mounting that there is actually something there. And finally, we believe that finding this culture matters contributes to our understanding of contracting because it provides some context as to why people do what they do and why it varies across different regions. Thank you.
I've written a lot about culture as an impediment to global convergence in corporate governance. I wrote these in Cornell. And I did a lot of work with the Pacific Rim. And you can just tell intuitively that in post-Confucian societies, the American model of corporate governance, based as it is on rugged individualism, isn't going to work. The convergence advocates, who I include Jack Potter in that camp, they just disregard it. Except that that's the yin. The yang is the international organizations, IMF, World Bank, Asian Development Bank, OECD, they want to erase any cultural impediments to finance and to governance. When I was in Indonesia for the State Department, the commitment of the international, the IMF, had 238 conditions that Indonesia had to satisfy to modernize their financial corporate laws and their governance to encourage direct foreign investment. So that's called the Washington Consensus. Friedman calls it the golden straitjacket. I think it's subsided now, but that's on the other side of culture being important determinants of financial considerations.
So just very quickly, and I'll let Rob respond too. That was one of the, we're still having difficulty convincing our colleagues that culture actually matters. A lot of my co-authors look at me and go, don't believe it. They would expect, well, but the strange thing is this person is Indian who went to INSEAD for his PhD, is now a chair professor at Cambridge after spending years in the US. And I look at Raghu and I go, how can you tell me culture doesn't matter? And their argument is, labor markets are global. It should all wash away. And I'm going, look at the data, it's not going away. But
I think also just to kind of relate it back to the theme of the day is that obviously agency theory is still quite viable, but it's not a one-size-fits-all theory. You have to relate it to the context in which it's applied. And I think the cultural context is one thing that perhaps some of our finance colleagues have been a little slow to grasp, and perhaps some of the supranationals or some of the entities that try to impose American capital markets in Russia, perhaps, didn't work too well. Very different culture over there. So I think this debate is a healthy one, but I think also there is still some work to be done to convince people that what's done in America might not work in these other countries.
Terrific. Thank you. Donna Nagy from Indiana University is a friend for many years, and was enthusiastic about coming here, but not sure what she was going to say. So I'm excited to find out and what take she has. It's kind of disconcerting. You're now following a group of people that say that law doesn't matter that much.
Yeah.
And here we are having a law conference, and we're told that culture and context matters so much more, and that actually what resides in individuals is even more paramount. So, Donna, help us out.
Great, I will. And so thank you, Alan, and thanks as well to Taryn and Will and the student organizers of this terrific symposium. So maybe I'll start out, since I've decided to go PowerPoint-less. I can start out with the title of my article, which is Making Money While Making Law, a Fiduciary Solution to an Agency Problem in Politics. Now, as many of you know, I've spent much of the last several years writing about topics at the intersection of corporate and securities law, which I teach, and government ethics, which I don't teach. What got me started on this intersection and these projects was a claim first profiled in the Wall Street Journal and then later reported in an episode or a segment on 60 Minutes that insider trading by members of Congress and their staffs was, quote, perfectly legal. So my initial challenge was to refute that claim by showing that members of Congress were fiduciaries who were deceiving and defrauding the general public if they used material, non-public government information for personal profit in the securities markets. Now, I like to think that the arguments I set out in a rather lengthy law review article would have carried the day were litigation initiated or prosecutions initiated on that matter. But Congress removed any doubt when it passed the Stop Trading on Congressional Knowledge Act, the STOCK Act. Gotta love the acronym, to reflect a basic fiduciary principle. The STOCK Act was passed a year ago, just under a year ago, and it amends the Securities Exchange Act to reflect a basic fiduciary principle that all federal officials, including members of Congress, owe duties of trust and confidence to the federal government and its citizens with respect to material non-public information obtained in the course of government service. Now, it was through my work on congressional insider trading and then subsequently on the STOCK Act itself that I began to see that many of the ethical questions with which government officials were struggling were at core the very same questions that corporate law had in fact resolved decades ago. More specifically, I drew insights from agency theory and the perhaps obvious observation that whether decision-making occurs inside a corporate boardroom or on Capitol Hill, acts of governing give rise to agency problems. Conflicts of interest exist in the corporate world, where the principals are a diffuse group of shareholders who entrust a board of directors to manage the corporation. And conflicts are also present in the political world, where the principals are citizens who entrust their leaders to manage the government. And so the fundamental challenge in both contexts is and lies with motivating agents to act in their principals' best interest. So my article for this symposium singles out another agency problem in politics, and that's the widespread practice among members of Congress of holding personal investments in companies that are directly and substantially affected by legislative action. Whether or not the perception is accurate, Congressional officials with investment portfolios chock full of corporate stocks and bonds contribute to a belief that lawmakers routinely place their own financial interests ahead of the public they serve. And so, to say the least, public trust in government is eroded when the public sees elected officials taking actions that have direct and foreseeable financial benefits to themselves. Now, this classic agency problem has been depicted in front-page news stories with jarring headlines, particularly over the last year. The Washington Post has published a series of articles aptly titled "Capital Assets." But despite the media attention and an all-time low in public approval ratings, members of Congress continue to own and actively trade securities totaling hundreds of millions of dollars in companies directly impacted by legislative actions. What's more, the membership of many congressional committees holds disproportionately larger investments in the corporations and industries subject to their oversight. So, for example, the House Transportation and Infrastructure Committee members, as a group, own 6 times more holdings in transportation firms, and senators, again, for example, on the Banking, Housing, and Urban Affairs committees, had an average of almost twice the value of holding in finance and insurance and real estate as the Senate chamber as a whole. Now, as we've heard a number of times today, fiduciary relationships involve multiple components, including a conflict component that prohibits fiduciaries from placing themselves in a position where their own interests conflict with their duty owed to the principal. There's also an avoidance component that prohibits a fiduciary from taking actions that would disable her ability to act impartially for the benefit of her principal. Yet, while few would dispute that members of Congress are fiduciaries who owe a duty of loyalty to the federal government and its citizens, it has generally been assumed that the prophylactic rules that guard against self-interested decision-making in corporations and in the executive branch of our federal government are unworkable and are unwarranted in the legislative branch. And so my article takes issue with this assumption, and it ultimately recommends changes that would restrict the types of personal investments that members of Congress may hold during their service as public fiduciaries. Now, given that this is an audience largely of corporate law professors or corporate law students, I needn't dwell for long on how the fiduciary duty of loyalty guards against self-interested decision-making by corporate executives. Under the common law, at least at one time, corporations or shareholders acting on their behalf were able to void a so-called interested director transaction at will, regardless of the fairness or the unfairness of that transaction. Now, the common law then moved away from a strict rule of voidability in self-interested transactions, and today, statutory provisions in Delaware, that's Section 144, and every other state typically specify 3 distinct ways by which a corporation can justify an interested director transaction. What's important here, though, is that in Delaware and every other state, interested director transactions stand as a fundamental exception to the business judgment rule that typically insulates decisions made by boards of directors. A board can regain that valuable presumption. A board can resuscitate the protections of the business judgment rule, but only if it effectively sanitizes that transaction with full disclosure and good faith approval by disinterested decision makers. If it doesn't, then a court looks into the entire fairness of the transaction. Now let me turn to government fiduciaries in the executive branch of the federal government. Federal officials in departments and agencies operate under strict ethical prohibitions against financial conflicts of interest that, for the most part, either meet or actually exceed the prophylactic rules that we would expect to see under fiduciary law. Financial conflicts of interest that could compromise objective decision-making in the executive branch are directly addressed in 18 U.S.C. Section 208, which is a criminal statute. It prohibits any officer or employee of the executive branch or any independent agency from participating personally and substantially in a particular matter that has a direct and predictable effect on the financial interests of the employee's spouse or minor children, or financial interests in basically any organizations in which this employee or family members are associated with. Now, unless a regulatory exception is available, Section 208 criminalizes conflicts created by personal investment holdings, even if the investment would be extremely unlikely to influence an executive branch officer or employee's official action. Now, although there is not a single government-wide statute that requires an executive official to divest financial holdings in circumstances where the disqualification that would be required under Section 208 effectively fundamentally interferes with a person's ability to do their government responsibilities, there's a host of agency-specific statutes that do require divestment. So this is Congress telling executive agency officials and their employees you can't own certain stocks in certain industries. For example, Federal Communication Commission employees are prohibited from holding financial interests in any company engaged in the business of radio or wire communication. Department of Defense folks can own stock in defense contractors, and actually that list is incredibly long there. And then agencies themselves have broad congressionally authorized authority to issue regulations prohibiting their employees from categories of financial investments in cases where the interest would cause a reasonable person, like all of us, to question the impartiality and objectivity with which agency programs are administered. And so we've looked at the corporate world, we've looked at the executive branch of a federal government. So now let's turn to Congress. The blatant financial conflicts of interest that have been reported by the press and captured on the Washington Post series and many other areas of scrutiny constitute standard congressional fare because the prohibitions in Section 208 do not apply to the legislative branch. To be sure, both the Senate and the House of Representatives have ethical rules that prohibit members and their staffs from deriving personal financial benefits from the use of their official positions. So the ethical codes start off really good. Say, can't take advantage of your position for private gain. But long-standing interpretations of those rules allow congressional officials to work and vote on legislation impacting their own personal investments. And here's the key, provided they are not the sole beneficiaries. Now, this sole beneficiary gloss substantially insulates congressional officials from the fiduciary principles that would otherwise operate to restrict their personal investment practices. As Congress sees it when it looks at its own conflicts of interest, public financial disclosure provides a means of monitoring and deterring conflicts. As long as they say what their investments are, that should be enough of an effective deterrent here. So consider, for example, one particular Senate rule, which is the rule that is said to prohibit senators from using their legislative power to advance their own personal interests. That's where it starts out good and then the devil's in the detail. The text of that provision says the following, and I'm going to read it here. No member, officer, or employee here of the Senate shall knowingly use his official position to introduce or aid the progress or passage of legislation, a principal purpose of which is to further only his pecuniary interest, only the pecuniary interest of his immediate family, or only the pecuniary interest of a limited class of persons or enterprises when he or his family control those enterprises. Notice the repeated emphasis on the word only. Your your observation and your urging of legislation needs to be only for your financial purpose for this to violate the Senate rule here. Now, in case this wasn't clear enough by the word only, the commentary explaining that particular provision describes it as narrow. You think? It also acknowledges that legislation, so it specifically acknowledges that legislation may have a significant financial effect on a senator because his or her financial holdings are involved. And so it says that. It says, we recognize that this rule allows a senator to own a tremendous amount of stock, to advocate for the passage of a bill that would help the company. And then it says, but the prohibitions in Rule 37 would decidedly not apply if that legislation also has a broad general impact on a state or the nation there. And so the specific example provided in the Senate commentary concerns a senator who was a dairy farmer representing a dairy farming state and who introduces, works for, urges, and then votes for legislation to raise or maintain price supports for dairy producers. And so the commentary observes that this senator is not doing anything wrong and is not falling within the strictures of the conflict rule. The commentary then explains, and here I quote, the strong presumption would be that the member was working for legislation because of the public interest and the needs of his constituents, and that his own financial interest was incidentally related. That's the strong presumption. Now, those of us who teach corporations, and those of you in the back who are studying corporations, should be struck by the fact that when personal financial interests are involved, political judgments, at least when they're made by members of Congress, are substantially more insulated from scrutiny than corporate business judgment. Interested directors are not granted a strong presumption that they are working for a transaction for the benefit of the shareholders and that their own financial interests are only incidentally related. In fact, the corporate world works just the opposite. In the absence of disinterested decision-making, corporate law subjects self-interested transactions to substantial scrutiny. Now, ironically, this disparate treatment between fiduciaries in the corporate world and fiduciaries in Congress is often justified by the public's interest in representation. That is, those who elect senators and congressmen are said to be entitled to have their elected representatives represent them by voting and fully participating in an aspect of the legislative process. And so there's been a real concern that if the corporate route of recusal is used, that this would effectively disenfranchise the public if their senators or their congresspersons were opting out of important legislative votes. But here's where fiduciary principles, once again, are so important. Fiduciary principles provide a solution that would protect the public's interest in legislative representation. Specifically, the avoidance, the conflict avoidance component I spoke about before would require a fiduciary to divest his or her financial holdings in circumstances where the conflict component would disqualify from exercising discretion in responsibilities fundamental to a position. So it's not just a matter of recusal. Fiduciary law gives us an avoidance route, and here divestiture, as done typically in the executive branch, would be another route completely open. So, no, I'm running out of time. Building on that theme, the final part of my article suggests a starting place. As a starting place, Congress should prohibit its members from holding equity or debt securities in companies substantially affected by the work of any congressional committee on which they hold membership. And so as a starting point, say, well, let's look as a parallel to the executive branch where the theory for divestiture or in some cases recusal, is that a certain agency is regulating a certain industry. Well, the fact of the matter is that is how legislation in the 21st century works in terms of how it goes through Congress. Committee chairs, ranking members, and committee members have tremendous power in shaping the legislation. Interestingly, the Senate already imposes that divestiture rule on committee staffers. So if you're a staffer in the Senate above a certain level working for the Senate Banking Committee, you must divest yourself of stock. The fact that we allow the senator and the chair of the Senate Banking Committee to hold individual stock, I find pretty extraordinary. My paper will go further than that, though. I think that's a kind of starting point change. I think that Congress should explore the adoption of even stricter anti-conflict measures, such as a statute or rule that would subject to some narrow exceptions, possibly even subject to a blind trust that might be used in limited type circumstances, but as a general rule, prohibit members of Congress from owning any securities other than shares in widely held investment funds that are not sector specific. And so maybe with that somewhat provocative statement, I'll close and open myself up for questions, if there's time out.
Sure. Questions? Can I ask a question?
Sure.
So we professors grade exams. Who's more out of integrity, Goldman Sachs or the Senate?
Well, you know, what I find most troubling about the Senate or the House is they're codified in their rules exceptions to fiduciary principles. So I think I'd have to say our Congress, in terms of codifying the exceptions this way, they're letting us know what the rules are, but boy, they write the rules that govern themselves. And so that doesn't hold lots of stock for integrity there. So
Great.
Thank you very much.
So our last speaker today is Angel Oquendo, who comes to us from Brazil on his way to Connecticut. And this is a great moment for me because Angel and I have known ourselves in two dimensions for so many years. We have met on a regular basis in my teaching a class on Latin American law using the terrific casebook that Angel put together on the subject. And this is finally my chance to discover that we both exist in three dimensions as well. Angel's talk is in some ways a great reflection on the two earlier talks. It's got an international cultural dimension and also deals with the question of how fiduciary norms ultimately are enforced.
So I put this in my pocket, so that's why I have the jacket here.
Makes sense.
And I just clip this on.
Right, and I think I put it on.
So is this working? Oh, beautiful. So now you can probably understand why it is that I'm not using PowerPoint. Low tech, it was a challenge enough getting the microphone on. Excuse me, and keeping track of my papers. Yeah, in fact, in an interview, the German movie director, Wim Wenders, when he was talking about contemporary movies, said that he had a feeling that in contemporary movies, the machines, the robots, the technology were upstaging the actors and the directors. So at any rate, I would easily be upstaged by technology, so that's why I'm just using old tech and low tech. Also, a challenge is going to be time. I'm going to be as brief as possible. I'm going to stay within the time allocated so that we have an opportunity maybe to have a conversation. The 17th century Spanish philosopher Baltasar Gracian said that what is good, if brief, is twice as good. And the other side of this, which he did not say, is that what is bad, if it's brief, it's half as bad. So, so let's keep this short. Also, I know I'm standing between you and freedom, so I won't go too long. And it's good that I have a clock to remind me of the time. Indeed, Alan is right that what I'm going to be saying connects with the two previous talks, even though I've changed the topic a little bit. I am going to talk about law, even though Alan and myself we had a couple of drinks last night, and we probably were remembering our youth, and we started talking about law in Marxist terms and saying law is superstructure. So, reminding myself of this conversation, I wanted to tell you that I'm going to talk about the law and the law's effect on things that we've been talking about today, but I don't want to exaggerate the role of the law. So in this sense, I'm not a true Marxist, but then on the other hand, I'm not mystified with respect to the role of the law and the place of the role of the law in terms of social economic phenomenon. Now, I'm going to talk about instruments that are very important in the enforcement of legal duties, in the enforcement of obligations and norms that are imposed on directors, on corporations. These well-known instruments are, of course, the derivative suit and the shareholder class action. And everybody who teaches corporate law has to talk about this at some point, so all textbooks include some discussion of this. And I'm trying to come to it from a different perspective. On the one hand, I'm trying to bring a public law approach to this very private law issue. I've been doing research for a while on citizen suits on the one hand and general regular class actions. Citizen suits, in theory, there are a lot of problems with this and we can't go into the details, are suits through which citizens enforce legal norms or constitutional norms. And general class actions, you know, are these devices, these suits that are filed under Rule 23 of the Federal Rules of Civil Procedure. And I think that there are parallels, which I'll make clearer in a second, between these two dichotomies. That is, on the one hand, the dichotomy that I'm going to talk about, derivative suit and shareholder class action, and on the other hand, citizen suit and general class action. Also, and this connects into what my original purpose was and my original objective was, I'm coming to this topic from a comparative perspective. So I've done a fair amount of work on European corporate law and on Latin American corporate law, and some of the ideas that I have developed on this topic have come from my comparative work. So first, I'll give you very quickly what I take to be the common view on these mechanisms. It seems to me that the common view is that these mechanisms are essentially similar. That is, these mechanisms provide a way to change the identity of the rights vindicator. So, ordinarily, it's the board of directors that enforces the rights of the corporation. In a derivative suit, then you have a shareholder withstanding to enforce the rights of, or the entitlements of the corporation. When it comes to shareholder class action, you have one shareholder that is enforcing not only his or her claims, but also is enforcing the claims of other shareholders. So ordinarily, you would have each shareholder enforce his or her claims. Now you have one shareholder enforcing the claims of everybody else. Also, it seems to me that part of this similarity is expressed in terms of collective procedure. So it is said, here we have two procedures that are collective. Now, of course, while these similarities are being spelled out, there's an awareness that there is a difference. But, I'm saying there is an essential similarity going on. And then it's also thought that these devices are there, and here's the connection to our topic, in order to correct management failure or management dishonesty. And therefore, the common view is an instrumental view of these devices. So these devices are used in order to achieve a particular result, specifically to make these corrections that I'm talking about. So it is what is referred to in the discussion on procedure, a dispute settlement model. So the idea is that these devices are there in order to solve disputes. Now, in this common view, as I suggested, there are differences, of course, important differences between these mechanisms, but these differences are seen as technical. So, on the one hand, it is said that the relevant procedural rules are different. So, if you're in a federal court, on the one hand, if you're bringing a derivative suit, you invoke Rule 23.1. If you are in a shareholder class action, you invoke Rule 23. There is a difference, and here there is some variation if you are in state courts with respect to how, when, how much on the security deposit that you have to file initially. There is a difference in the pleading requirements that we talk about in our corporate law classes. There is also a very important difference, and we talk even more about this, on the exhaustion of internal remedies, what I would call the exhaustion of internal remedies, borrowing a little bit of the jargon from administrative law. And that is, maybe this is clear already, but it is that in corporate law we say, well, you first have to go through the corporation, you have to make a demand. It sounds a little bit like what you have to do when you're bringing a case in the area of administrative law. There are also two additional differences that courts have used in order to distinguish these two procedures. One is the locus of the injury. That is the injury an injury to the corporation? Is it an injury to the shareholders? And also, there is a difference in terms of the appropriate remedy. In case of the derivative suit, then the compensation, if we're talking about compensation, goes to the corporation. If you have a shareholder class action, then the remedy or any compensation benefits the shareholders directly and not indirectly. Now, the alternative paradigm kind of stands things on their head and says, well, there is a convergence, and the convergence is formal. You have collective litigation in both cases, although we will see that both kinds of litigation are collective in different ways. We're also talking about representative litigation. So you have litigators that are litigating on behalf of someone else, so that is also a similarity, a formal convergence. In terms of the instrumental dimension, to go back to what I was saying, seeing the procedure as being directed towards a particular objective, well, dispute resolution is part of what these mechanisms seek in common, although we're going to see that there are other objectives. And then what I have argued in the past is that these mechanisms, like other mechanisms, have to be approached reflexively, and that is not only instrumentally in terms of objectives, but also in terms of the own reality that they create. And there is a reflexive dimension that is common. There is a dimension that is reflexive that is not common. But the common dimension is, well, you have shareholders and directors, and these procedures are about the relationships between shareholders and directors. Also, the central, with respect to the central problem, there is a formal convergence, and that is adequacy of representation. Now, the divergences, I think, are more interesting, and I refer to them as critical divergences. So, as I suggested earlier, we're talking about collective litigation, but collective in a different sense in these two devices. And when I think of the differences, I remember a joke. It's an old joke that you've probably heard, which is the joke of the guy. It's a Russian joke. So in cold Siberia, this guy goes to a bar, and he goes to the bar for the first time, and he orders 2 vodkas, 2 glasses of vodka, and the bartender serves him, sees he's alone, but serves him the 2 glasses of vodka. And the man drinks 1 sip from one glass, 1 sip from the other glass, and continues on this till both glasses are empty, and then orders 2 additional glasses of vodka. And the bartender brings the 2 glasses, but now is wondering what is going on. So he says to the client, excuse me, I know I should mind my own business, but I was wondering, why is it that you order 2 glasses of vodka at once? And the customer says, well, it happens that I usually drink with a very good friend of mine, and he's a sailor, so he's out at sea. So I come here and I drink 1 vodka for me and 1 vodka for him. And the bartender says, well, that makes sense. Sure, that's actually kind of funny. So the man is done, he leaves, and he keeps coming back every day, and it's the same routine. And it's an inside joke. Oh, here comes the guy who's going to order 2 vodkas. Now, a couple of weeks later, he shows up, and he orders 1 vodka. And he drinks a glass, and then he orders again only 1 vodka. So the bartender goes up to him and says, excuse me, if I may ask you a question, did something happen to your friend? And the man says, well, which friend? He says, no, your drinking buddy. And he says, no, he's fine. Actually, we talked on the phone the other day. No, he's doing great. And the bartender says, well, why are you ordering only 1 glass of vodka? And he says, well, it turns out that I decided to stop drinking. So I just order my friend's vodka, my friend's vodka. So, the reason I think of this is because, counterintuitively enough, when you bring a derivative suit, you are actually drinking a vodka for someone else, procedurally, because you are actually vindicating the rights of the corporation, which procedurally is someone other than yourself. Now, when you bring a shareholder class action, then you are drinking 2 vodkas, or 1 for yourself and 1 for your buddy. Actually, in one of these class actions, it could be, I don't know, it must be actually an innumerable number of vodkas for you to qualify. So this is the difference in terms of the collective. In fact, in my opinion, only derivative suits are genuinely collective devices. What happens most of the time with shareholder class actions is that you're bringing an aggregation of individual claims. You're just bringing them together, and you have this very convenient device to do so. Here there's a footnote, and I'm not going to get into these details because they're a bit complex. There is an exception with the class actions, and those are class actions that are brought under 23b2, where you have what looks like a genuinely collective action. But most actions that are brought on behalf of shareholders are brought under Rule 23b3, and therefore they're an aggregation of individual rights. Now, when it comes to representative litigation, I said formally, well, both are representative, but the representation is different. On the one hand, in derivative suits, you're representing the shareholders as a collectivity. In the other case, you are representing the shareholders as individuals. And I mean, by the way, part of the confusion between the two kinds of devices is, and I'm not going to get into these details either, that originally the derivative suit emerged as a combination of a class action suit and a derivative action. And that's why when you read Rule 23.1, you have language that makes sense for a derivative suit, but then you have talk about similarly situated other individuals, which is language that pertains more to a classical class action. So, I mean, this is what creates some of the problems. Now, there is an instrumental dimension, but with respect to derivative suits, even though dispute resolution is part of what is sought, most of the time what is sought is what could be referred to and what is referred to procedurally as structural reform. I have referred to it as institutional reconfiguration. So you're not simply looking to solve a dispute, but you're pointing out to a basic problem with an institution, and you're trying to transform, reconfigure the institution. So, I mean, the consequence of this is, first of all, with respect to derivative suits, and I'm just going to focus on derivative suits, you focus on future possibilities rather than on the status quo ante. You're not addressing a harm that you want resolved. Secondly, the relief often is injunctive rather than compensatory. You have more of what is referred to as managerial adjudication when you have a derivative suit. And you have almost, so shall we say, quasi-permanent jurisdiction in cases in which there is a derivative suit as opposed to an individual suit. Now, there is a reflexive dimension. I'm not going to say much about this, but in the case of derivative suits, you're representing the individuals, as I said, as a collectivity against the directors. And then the central problem is different in these two kinds of devices. With respect to derivative suits, the central problem, central challenge is the preservation of autonomy. I mean, you have a group that has chosen, hopefully with some freedom, its directors, its leadership, and then all of a sudden, a different group of individuals is taking over this leadership. So there are autonomy problems that have to be addressed. In a class action, and specifically in a shareholder class action, the problem is individual due process. I mean, how do you protect the rights of the absent shareholders? So there are very different central problems in these two cases. Now, the consequences of this I can't elaborate on, but I'll just list them. One is that I think that if you look at these devices in these terms, you will, I think, be in a better position to distinguish the direct claim from the derivative claim. And what you'll be led to is to focus on the right involved. If you look at the case law, I think that the Delaware court has been coming close to a very good standard. It focuses on the injury and the remedy in order to determine whether the action is derivative or direct, but it doesn't talk at all about the right. I think it assumes that the right and the claim are the same thing, and that focusing on the right is not going to provide much illumination. And I think that if you take the approach that I'm suggesting, you will end up focusing on the right. Now, the other thing is that you focus then, when you come to the derivative suit from this perspective, on issues such as participatory democracy. I said the problem in the derivative suit is preserving autonomy of the group. And the temptation, and I think this is a classical view, is to say, well, it's an illegitimate device. You allow it exceptionally when there has been a problem with the normal autonomy structure. But it's only intermittent and it's only exceptional. And I think that if you take a broader approach, and I'm pushing for this broader approach, then you will say, well, the device is not going to work only exceptionally and externally as an intervention, but actually you're going to have more continual internal participation. The final point here is that by examining these devices, the derivative suit, the shareholder class action, just as when you look at citizen suits and general class actions, I think you get a better understanding of what collective rights are. And I mean, this may seem unimportant, but the concept of a collective right is philosophically very problematic. And a lot has been written about this concept, and there is a tradition, a very strong tradition in philosophy that says there is no such thing as a collective right. The fear is that the individual gets lost when you start talking about the collective. And I think that if you look at these institutions, at these devices, and you see the way in which these collective rights are enforced, you see that, of course, ultimately, the rights are about individuals, but they are of a different nature. And in order to understand what's at stake, you have to understand autonomy, you have to understand the group, and you have to understand the concept of the group determining itself, that is self-determination. But anyway, I'll stop at that, and I welcome any questions that you may have, or comments or criticisms. Sorry, that was going so fast.
Comment, question? I think my role is to wrap up with concluding remarks, and I don't have many except to